Hello and good morning to everyone, especially to our lecturer, Madam Amani, and our fellow classmates. We are from Group M. The member of Group M are Anisiana, me myself Amir Haikal, Putri Izzah Dalila, Tay Siang Rong, and Teo Kai Xiong. The topic for our assignment is the prohibition on the discrimination on individual on public international law. I will pass to my next member.
Okay, hi, and my name is Anisiana. So I will explain a little bit on the introduction. Next. So equality distinctly stated that every person in this world must get the same treatment, no matter race, religion, and background that they hold. Equality asserted that all individuals that have been born into this world are free and equal. Equality also has been one of the symbols of constitutive features of justice and fairness to all individuals, whether formal or in a moral sense. Next. In the beginning, human beings are considered unequal by nature. They were not given the same rights up until the 18th century. Before 1945, most people do not care about discrimination. Discrimination is prohibited only in the so-called minorities treaties that were relentlessly limited only in their scope. After a few issues arises due to the discrimination, a non-discrimination clause in the United Nations Charter is applied to every individual. After adopting this clause in the UN Charter, non-discrimination had been recognized as part of international law. Okay, next. Under the UN Charter, there are three main provisions scrutinize human rights, namely under Article 1, Clause 3, 55C, and 56. Article 55C stated that human should give universal respect and give full observance in human rights and the fundamental freedom to all individuals without differentiating them regarding race, language, sex, and religion. Human rights are also a fundamental part of the UN Charter. The aim was to develop relations among other nations on the basis of respect for the principle of equality and the absolute freedom to all of the individuals without any discrimination. So next, I will pass to my members.
There are many sources of non-discrimination and equality in discussing the topic. First, the Charter of United Nations, UN Charter. Before 1945, the prohibition of discrimination was severely limited in their scope as was only dealt with the minority treaties. So the Charter was signed on 26 June 1948 and came into force on 24 October 1945. The Charter provides an instrument of the United Nations. It codified the major principles of international relations, from sovereign equality of states to the prohibitions of the use of force in international relations. So it sets out the rights and obligations of member states and establishes the principal organs and procedure of the United Nations. So the Statute of the International Court of Justice is an integral part of the Charter. The UN Charter is an international treaty and the UN member states are bound by it. For article of the Charter made it clear that human rights protection is fundamental part of the UN nations. So this can be seen in Article 1, Article 15, Article 55, Article 56 of the Charter. And second is Universal Declarations of Human Rights, UDHR. So UDHR was adopted unanimously by the UN General Assembly on December 10, 1948. So the Universal does not directly create a legal obligation for countries as it is not a treaty. The UDHR comprises of 30 articles that contain a comprehensive listing of key civil, political, economic, social, and cultural rights. Non-discrimination and equality are core elements of the UDHR legal framework, which contain international instruments to combat specific forms of discriminations, including discriminations against indigenous peoples, migrants, minority, people with disability, discriminations against women, racial, and religious discriminations or discrimination based on sexual orientation and gender identity. The UDHR elaborates the UN Charter regarding the right of non-discrimination and equality. This can be seen in the Article 1, Article 2, Article 7 of the Declaration. The third, International Covenant on Civil and Political Rights, ICCPR. So the International Covenant on Civil and Political Rights was adopted by General Assembly and came into force on 23rd March 1976. And this treaty is binding upon the state that ratify it as they voluntarily accept the legal obligations under the international laws. So the Article 26 of ICCPR provides that all persons are equal before the law, thus entitled without any discrimination to equal protections of law. And fourth is International Covenant on Economic, Social and Cultural Rights, ICESCR. So the International Covenant of Economic, Social and Cultural Rights is a multilateral treaty adopted by General Assembly and came into force on 3rd January 1976. Since the covenant is an international treaty, the obligations are legally binding internationally to those states that have agreed to be bound by it. Next can be seen in Article 3, Article 7, and Article 7 C. And last one is treaty in specific field. And the first treaty that we use is International Conventions on the Elimination of all forms of racial discrimination. So the convention was adopted by General Assembly and came into force on 4 January 1969. So the objective of this convention is to adopt all necessary measures and guidelines for speedily eliminating racial discrimination in all its forms and manifestations, and to prevent and combat racist doctrine and practice to promote understanding between races, and to build an international community free from all forms of racial segregation and racial discrimination. And the second convention is Convention Elimination of All Forms of Discriminations Against Women. So this convention was adopted by General Assembly and entered into force on 3rd September 1981. The convention defines the terms discriminations against women as any distinctions, exclusion, or restriction made based on sex that has the effect of or purpose of impairing or nullifying the recognitions, enjoyment, or exercise by women irrespective of their marital status based on equality of men and women or of human rights and fundamental freedoms in the political, economic, social, cultural, and civil, or by any field. Next, I will pass to my other member.
So we will discuss on the definition of and nature of equality or discrimination. We also will discuss on the right to equality on individual. Next. So the Encyclopedia of Public International Law define equality as the corrective of the law. The concept of right to equality is originated from the Aristotelian thought that the legislator could draft law in general terms only where the effect of the law could not achieve the intended purpose in every case. In exceptional circumstances, the law needs to be modified by equality for the sake of a just result. This concept also can be referred to the case to the North Sea Constitutional Shelf case, where the ICJ held that equality is not only a matter of abstract justice, but it is a rule of law that contains equitable principle. Beside the Tunisia-Libya continental shelf, the ICJ held that equality is a general principle that is directly applicable as a law, but also is bound to apply this concept as a part of international law and subject all various considerations to bring about an equitable result. Next. The concept of discrimination is defined as a set of difference in treatment which has particular effect that is formed on an expressly prohibited ground. The concept of discrimination and equality are two concepts that contrast with each other. It is commonly accepted that equality and non-discrimination are positive and negative statements of the same principle. Next. The right to equality of individuals, as stated by my member, the Universal Declaration of Human Rights provides the right to equality of individuals. In Article 1, it stated that all human beings are born free and equal in dignity and rights. Article 2 provides that all rights and freedom provided for in this declaration shall be guaranteed to all persons without prejudice to their distinction, such as race, color, sex, religion, political or other belief, national or social origin, wealth, birth, or other status. In Article 7, it stated that all are equal before the law and have the right, regardless of the equal protection of the law. Everyone has the right to equal protection against any discrimination. Contrary to this statement, and an incitement to such discrimination. Next. The International Covenant on Civil and Political Rights (ICCPR) also provide the right to equality of individuals. In Article 26, the right to equality before the law and freedom from discrimination is protected where it calls for states to take measures against discrimination by public and private agencies in all sectors. The Article 2 provides the legal obligation is both negative and positive in nature, where the state party must refrain from any violation of the right recognized by ICCPR, and any limitation on any of those rights be allowed under the relevant provision of the ICCPR. In the case where the limitations are made, the state must prove their necessity and only take such action as are proportionate according to the legitimate purpose to assure the constant and practical of the protection of ICCPR rights. I will pass to my member.
I'm Sarah and I'm going to discuss the next subtopic, which is defining the prohibited grounds of discrimination. Basically, there are three models. Model is by means of exhaustive list of grounds. This model is found in UK anti-discrimination legislation and the law of the European Union. This list of grounds is based in the EC Treaty, which are nationality, sex, racial or ethnic origin, religion or belief, disability, age or sexual orientation. The prohibited grounds of discrimination can be added or removed by way of legislation only. The court has the right to recognize the prohibited grounds of discrimination within the scope of protection. However, this approach may cause some tension when the protection of non-discrimination law falls to cover groups and individuals marginally outside the boundaries set out by the list of prohibited grounds of discrimination. Referring to the first case, which is P versus S and Cornwall County Council, whereby the ECJ has extended the scope of sexual equality to discrimination against transsexual, and this decision appears to be the highest marks to the principle of equality on the grounds of sex, as individuals should be treated alike. And refer to the second case, Lisa Jacqueline grounds, the ECJ held that the community non-discrimination law did not cover discrimination on the grounds of sexual orientation. And to improve it, the sexual orientation has been a subject of legislative proposal, and in fact, the word sex in Article 28 of the ICCPR has included sexual orientation. The second model is through a broad, open textual model. This model is exemplified by the Equal Protection Clause of the 14th Amendment to the American Constitution, which states that no state may deny to any person within its jurisdiction of the equal protection of the law. And the purpose of this amendment is to eliminate race-based classification. The spirit of it extends to multiple additional classification. This can be seen in the case of United States versus Caroline Products, whereby concerning the 14th Amendment, the U.S. Supreme Court has partly filled this gap by its concept of suspect classes, primarily referring to race and alien status. The third model is specify a list of grounds of non-discrimination, but within the non-exhaustive list. And this has been adopted in the ECHR 1915, whereby it stated in Article 15. The process of updating the list has been facilitated by the court, and this approach consents the appropriate boundaries of judicial scrutiny. In the case of Abdul Aziz Kabas and Bakatali versus the United Kingdom, the court laid down the rule that not every difference of treatment amounts to discrimination unless It has no objective and reasonable justification. And in other case, Sagriro Tau Silva Mota versus Portugal, whereby Article 14 of the ECHR has been applied on the grounds which are not explicitly mentioned in the provision. The next subtopic is the implementation of the principle of non-discrimination, and this can be seen in two ways. The first way is enforceability of the UDHR. UDHR has been universally accepted and it's part of the customary law of nations and binding in all states. And there are two presumptions of Article 1 of the UDHR. The enforcement of human rights provided in the UDHR as the basic structure of the Indian Constitution, and this can be referred to the case Kansavanata Bharati Sripada Gavaru versus State of Kerala. The UDHR is a fundamental basis to form a constitution, and the judiciary constantly refers to it in the scope of fundamental rights. The second way is state obligation. The state complies with the obligation to respect, protect, and fulfill the recognized human rights as addressed under the international human rights law. The state have a responsibility to ensure compliance by private persons against private interference, whereby with the enjoyment of the rights protected in the European Convention. This can be referred to the case SNY versus the Netherlands, whereby the court held that the states obliged to adopt legislative measures in relation to individual rights in accordance with the ECHR. And I pass the next floor to the next member.
My name is Teo Kai Xiong, and I will be discussing on the importance of the principle of non-discrimination. A society without any discrimination will positively affect the growth of an individual. Unequal societies are more towards dominance instead of empathy and inclusion. And education is crucial to shaping a better personality of an individual, eventually ensuring the economic growth. For an individual to success, it brings a lot of advantages such as a higher chance of employment, higher salaries, better health, higher work satisfaction, and a lower tendency for criminality. Without any discrimination, individuals will feel more confidence and more happiness to improve their memory and problem-solving skills. Nowadays, violence and crime are apparent to be seen. However, the fear of violence and getting hurt is as big as the crime itself. People are told not to open doors at night or talk to strangers even if they claim to be an emergency. And violence is done to eliminate the feeling of shame and humiliation and replaced by the sense of pride. This can be seen in the differences in wealthy areas and poorer areas. In wealthy areas, people are not feeling the need to insult people by violence as their high status, and while in poorer areas, people tend to insult by violence as they tend to obtain their satisfaction and pride towards their actions. Therefore, everyone should be treated equally to avoid more crimes from happening. As a conclusion of this topic, all individuals that have been born into this world are free and equal. All individuals deserve equal treatment even they are different in race, sex, religion, color, or language. It is very optimistic that the international covenants such as the UN Charter, UDHR, ICCPR, and ICESCR lay down, and also the other treaties lay down on the principle of equality and non-discrimination. However, there are still people out there suffering from discrimination, and this is where the international treaties and covenants need to be amended in order to overcome those problems arising due to the discrimination. Lastly, the discrimination needs to be eliminated by the unity and teamwork from all of us as the individuals that will preserve the better life of the community. That's all our presentations on the topic Prohibition of Discriminations on Individuals on Public International Law. Thank you very much.